Tinubu tells the United States court that Freedom of Information Act is to expose government activities and not individual records. The United States government will give its position today regarding the motion filed by President Bola Ahmed Tinubu to intervene in an emergency motion filed on Friday at the United States District Court for the District of Columbia, seeking the release of records relating to his residence in the country. An IT consultant in the person of Aaron Greenspan, on July 21st, 2022, filed a Freedom of Information requesting and asking the country's agency to release Tinubu's record. Greenspan filed an emergency motion on Friday, October, seeking the immediate release of the records. Tinubu argued that the Freedom of Information Act, its purpose is to provide access to government activities, not as a means to obtain records of individuals compiled by the government. The defendants in the suit are the Executive Office for the United States Attorney, the Central Intelligence Agency, the United States Department of State, the Federal Bureau of Investigation, the United States Department of the Treasury, the Internal Revenue Service, and the United States Drug Enforcement Administration. Now, Tinubu subsequently filed a motion to intervene or be an intervenor in the case. He had filed an application before the court to stop the country's agencies from releasing the records related to his residence in the country. The motion to intervene in the case between Aaron Greenspan, who is the plaintiff, and the Executive Office for the United States Attorneys et al., with the defendants, with civil action number 231816, reads: Bola A. Tinubu moves a motion pursuant to the Federal Rule of Civil Procedure 24 to intervene in this action because plaintiff seeks production of Mr. Tinubu's confidential tax record, which the Internal Revenue Service is prohibited from disclosing by federal law, and documents from the federal law enforcement agencies that falls within the Privacy Act or exceptions to the FOIA and should not be disclosed. Mr. Tinubu should be allowed to intervene because he has a direct interest in the record sought. His interests are not fully represented or protected by defendants, and his interests will be adversely affected if he is not permitted to intervene. Plaintiff Greenspan has indicated that he will oppose his motion. Mr. President Bola Ahmed Tinubu's counsel now reached out to the government in October seeking the government's position. The government asked for additional information and responded that it would give its position by evening of October. Now, because plaintiff filed an emergency motion on October 20th, Mr. Tinubu filed his motion prior to receiving the government's position. The argument reads in part that the Federal Rule of Civil Procedure, Rule 24A, provides for intervention as of rights on timely application by anyone who claims an interest relating to the property or transaction that is the subject of the action and is so situated that the positions of the action may, as a practical matter, impede the movant's ability to protect its interest unless the existing parties adequately represent that interest. Now, intervenor must meet 4 requirements to intervene as of right. 1 is the motion for intervention must be timely. 2, that the intervenors must have an interest in the subject of the action. 3, their interest must be impaired or impeded as a practical matter absent intervention. And 4, the would-be intervenor's interest must not be adequately represented by any other party. Now, it is noted that the four requirements for intervention as of right are met here. It says, wherefore, Tinubu requests that the court grants this motion and such other and further reliefs as deemed appropriate under the circumstances. The argument reads that the Committee for Freedom of Press 489 United States 749 addition, the Privacy Act, contains limitation on disclosure of records gathered by the government officials. Now we should see example of the 5 United States C Section 552A, which reads that no agency shall disclose any record which is contained in a system of records, except pursuant to a written request by or with the prior consent and written consent of individuals to whom the record pertains. An intervener has protectably interest in the material that is subject matter of this action. Intervener also has a protectable interest, and intervention is appropriate here because defendants appear to be producing records about interveners, not about defendants' activities. Now, as the Supreme Court explained in Reporters Committee for Freedom of Press, FOIA's purpose, that it is to provide access to government activities, not as a means to obtain records of individuals compiled by the government. Interveners has a heightened interest and the government a lesser to non-existent interest in requests seeking information that the government may have collected about him. Now, that is Tinubu's motion to block the FBI, the CIA, and other agencies, including the United States organization, from bringing out information relating to him by the Federal Bureau of Investigation, 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 by the Federal Bureau of